seated.
Jurors, that was a more leisurely break than I had anticipated. I hope people are hyper-caffeinated. The defense is going to call its first witness. Mr. Scully?
Thank you, Your Honor. Defense calls Michael Kahn.
Stand behind this blue line and face the court.
Sir, would you raise your right hand for me, please? Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Good morning.
Good morning.
Morning, sir.
Good morning.
Okay, so that microphone both projects your voice so that the jury and others can hear you clearly, and there's a recording system connected to that microphone, so best you can stay fairly close to that, okay?
Okay.
Can you please state your name and spell your last name for the record?
Sure. Michael Kahn, K-A-H-N.
And Mr. Khan, what do you do for work?
I'm a chemist.
And where are you currently a chemist?
I'm a chemist at MCR Labs.
Okay. I'm going to ask you to describe your educational experience, starting with high school.
Sure. I attended Brookline High School. I graduated in 2001. I then attended Mass Bay Community College for 2 years. I then attended Brandeis University, where I graduated with bachelor's degrees in physics and chemistry and a master's in chemistry. And then I attended a PhD program at Boston University, which I left after 3 years to join the private sector.
Okay. So you completed your master's degree, spent a substantial time studying for your PhD, but didn't complete that process at the end, right?
Correct. Yes.
And when you got your master's degree, what year was that?
I went from Brandeis in 2006.
Okay. Was there another master's degree from BU?
Yes.
What were those in?
Chemistry.
Okay. Now, have you published any works related to your field?
In chemistry, yes, there was a platinum paper and then a separate crystallography paper for the crystal structure of THCA.
What is THCA?
Tetrahydrocannabinolic acid.
Okay. Now, as far as your employment background, starting maybe at BU and moving forward, did you work at Boston University for a time?
I was a research fellow and a teaching fellow, so I taught chemistry and I taught chemistry classes and laboratories, and I did research there.
And do you remember the approximate years that was?
That was 2006 to 2009.
That was when you were in the PhD program?
Yes, concurrent.
Okay. And then after you completed working at Boston University in 2009, you took a job in the private sector?
Yes.
Where did you go to work? What was the name of the company you worked for?
It was Shiloh House Jewish Day School, elementary school.
And what did you do there?
Science and math teacher for grades 1 through 5.
How long were you an elementary science and math teacher for grades 1 through 5?
1 year.
1 year. Mm-hmm. And then did you go on to work somewhere else?
Yes.
Where next?
Next was Wolf Laboratories in Watertown. I was a scientist. Wolf Laboratories was a contract research organization, so I did work to develop drugs for pharmaceutical and biotech companies.
Okay. And how long did you stay at Wolf Laboratories?
Oh, approximately, 3 years, 2 to 3 years.
Okay. After working at Wolf Laboratories, what did you go on to do professionally?
I founded MCR Labs, an analytical testing laboratory.
That's where you work now.
Yes.
And can you tell the jury, please, give a common language type of explanation for what MCR Labs is and what they do?
Sure. MCR Labs is an analytical chemistry and microbiology laboratory, which means that we measure the amounts of contaminants and active ingredients. We specialize in natural products, and most specifically, we specialize in cannabis testing.
Okay. And does the lab hold any accreditations?
Yes, the laboratory is ISO 17025 accredited.
What does that mean?
That means that we are regularly audited by an international organization for standardization. We document our processes, we follow them, we have training records for our employees, we keep records of everything that we do. It's a widely recognized standardization benchmark.
Okay.
Yeah.
Now, was there a time that you were contacted to work in this case?
Yes, it was in the spring of last year.
Okay, so spring of 2025?
Yes.
Fair to say that the defense team had reached out to you at some point
Yes.
and that we had been connected by other professionals in your industry?
That is correct.
Okay. Now, did you agree to take on some work relative to this case?
Yes.
And what was the big picture work that you agreed to take on?
We agreed to develop and validate a method to measure the amount of denatonium benzoate in a sugary drink with ethylene glycol in it.
Okay.
And then to also measure the evidence sample that we received for the same substance.
Okay. And the evidence sample that you received, did you come to learn that that was an evidence sample that was taken from a certain Powerade bottle relative to this case?
Yes.
Okay. Now, when you started prior to doing this work in this case regarding denatonium benzoate, had you ever worked or had experience working with denatonium benzoate in other circumstances?
Yes, I have.
Okay, and briefly, can you tell the jury what it was, that experience?
At my prior laboratory at which I worked, at Wolf Laboratories, when I developed a drug, you also need to develop a placebo. So a placebo is something that doesn't have the active ingredient of the drug, but is made to look, feel, taste like the drug. And denatonium benzoate was used to make the placebo as bitter as the drug.
Okay. And so, and what is, based on your experience in that case and your experience as a chemist, what is denatonium benzoate?
Denatonium benzoate is, from my experience, one of the most bitter substances known. It's extremely bitter. It's used as a taste aversion substance to make, which means that it is used to prevent people from ingesting whatever it's put into.
Okay, and is there a commercial name that denatonium benzoate is commonly sold under?
Yes, there are several, but the most common that I've heard of is Bittrex.
Bittrex.
Yep.
So similar to Tylenol, for example, is a commercial name, and there's a
Right.
medication that's underneath it, right?
Correct.
So Bittrex would be a widely common name. Denatonium benzoate is the ingredient primarily in it.
Correct.
Okay. When you started to do the work, in this case, to do the testing you just described, to see if denatonium benzoate existed and to measure it in the sample that came from the Powerade, did you divide that work into basically two different phases?
Yes, depending on how we characterize them. Yes, yes.
And what generally was phase one?
Phase one was developing the method and then validating the method, which in layman's terms means that we made sure that we can measure denatonium benzoate in a sugary sports drink type matrix with ethylene glycol in it at various levels. And then the validation portion is to confirm that the method works as intended. And then phase two would be the measurement of the actual sample that we received.
Okay. And were you able to successfully complete your work in phase one?
Yes.
And did you generate a certain report at that time or the like?
Yes, the validation report. Yeah.
Okay. So having completed your phase one work, is there a phase two that you undertook to do?
Yes.
And what was the goal, in phase two?
To measure the amount of denatonium benzoate in the sample that we received from the court.
Which again is the Powerade sample, is what you were informed, right?
Correct.
Okay. Now, were you able to perform that phase two work satisfactorily?
Yes.
And did you document the steps that you took?
Yes.
And was your laboratory able to reach any conclusions?
Yes, we measured denatonium benzoate in the sample that we received.
Okay. So the sample that you received, which was the Powerade sample now, was tested basically positive for denatonium benzoate, right?
Yes.
Okay. And then was there a next sort of part of the phase to now measure, okay, it's in there, but how much is it in there?
Yeah, we measured it 3 times. So what we do in this phase is take certified reference materials. We create what is called a linear curve. Therefore, we take a certified reference material, which a different laboratory produces in pure form. We create several different concentrations, so different amounts of the denatonium benzoate. We inject all of them on high performance liquid chromatography with tandem mass spectroscopy. We measure the signal that we get from our created linear curve, so different amounts of denatonium benzoate as injected on the instrumentation. And we compare in triplicate dilutions of the sample from the court, the evidence sample that we received, and we compare it all at once to the samples that we prepared from certified reference materials. What we found was those 3 measurements came in at 116 parts per million, 112 parts per million, and 113 parts per million for an average of 114 parts per million denatonium benzoate.
Okay. And so at that point, did you prepare a certificate of analysis to document your work?
Yes.
And your conclusions?
Yes.
Okay. And do you recall the date that the materials were tested?
I don't recall off the top of my head, but it's here. I can look at
Your Honor, can he refresh his memory with the certificate of analysis? It's
Yes, you
been
may.
provided.
Go ahead, sir.
The report was issued on September 17th,
Okay, 9/17 of what year?
2025.
Okay, and so basically you received the sample in June of 2025, is that right?
Correct.
And then we're engaged in the phase 1 and phase 2 testing in the late summer and early fall of 2025. And then, is that right?
Correct, yeah.
And then completed, documented, issued your report in September of 2025.
Yes.
And that date again was which one?
17th.
17th, okay. And that was, you took the average of the 116, 112, 113 parts per million, and And that was 114. Is that how the 114 arrives?
Yes.
Okay.
Okay, I'm sorry. May I go back?
Yeah.
The date that it was tested, it's not an instantaneous process. It was from September 12th through the 17th. Is
Okay.
Yeah.
So the active testing was in that,
In that range.
5-day period
Yes.
or so. Completed, reported on the 17th
Correct.
of December 2025. And then fair to say that you produced your certificate of analysis and your underlying documentation and work product to the defense team, correct?
Yes.
And what about the sample?
What about the sample?
Do you recall where that is right now?
There's pretty much none left.
Okay, so most of the sample was used
Yes, it's used up.
in the testing. right?
Yes, yes, yes.
And that's documented as part of it, right?
Yes.
Okay, so the number, the 114 parts per million of denatonium benzoate, what does that mean?
So parts per million is a weight-based measurement, which means that for every unit of weight of the drink itself, there are 114 parts per million of the denatonium benzoate. It goes from percentages. It's 1 part per 100. 1% is 1 part per 100. 1 part per 1,000 is 1/10 of that. Well, 1 part per million is 1/1000th of 1/1000th.
And are you aware of a mass general law that applies, that states how much denatonium benzoate is needed in antifreeze and engine coolant products that are sold in Massachusetts?
Yes, I believe that range is 30 to 50 parts per million.
Okay, so this score that came in is substantially higher than even that amount, right?
In our sample, yes.
Okay, and is it fair to say your amount, the 114 parts per million, is a measurement of the sample that you received in 2025, right?
Yes.
And does that mean that it had 114 parts per million if it was originally obtained in November of 2022?
Not necessarily.
Right, so that you're not able to test what were the conditions in 2022, right?
Correct. I can't do that.
You can't do that. You can just take the sample that was given and do the testing on that sample.
Only as we receive it, yes.
Okay. And again, that's the sample of the Powerade bottle that, from the Powerade bottle in this case, as far as you know. Yeah.
As far as I was told, yeah.
Okay. No further questions, Judge.
Mr. Camellia.
Thank you, Judge. Before I get started, I'm just going to borrow the stapler here. Good morning, sir.
Good morning.
So you were telling us a little bit about your lab at the beginning of your testimony, correct?
Yes.
And you mentioned that you guys are accredited, correct?
Yes.
Your accreditation, however, only is for testing marijuana and cannabis products, correct?
It is for specific tests and specific analytes. Yes. Yes.
That are all, so my question was correct?
Yes.
Yes. Okay. So you're not a forensic laboratory, correct?
Correct.
You have no certification and no accreditation to do any sort of forensic testing, correct?
Correct.
And the accreditation process for a lab like yours is significantly different than an accreditation process for a forensic laboratory, correct?
I don't know.
So you don't even know what it takes to be accredited as a forensic laboratory, correct?
If it's ISO 17025, then I have a good idea.
Okay. So aside from the testing that you performed in this particular case, all of your testing that you're accredited to do is for cannabis inflorescence, plant matter, cannabis concentrate extract, and cannabis infused products, correct?
That's what we need accreditation for, yes.
Now, you told us that you have some professional knowledge about denatonium benzoate, correct? Denatonium benzoate.
Yes.
All right. And are you familiar with the studies involving the use of denatonium benzoate to prevent people from ingesting objects that contain I'm just going to say the Bitrex because it gets a little bit long. Is that fair?
Somewhat.
Somewhat. Okay. So you are familiar with the fact that every study that has been done regarding the addition of bittering agents to household products such as antifreeze cannot be justified on any actual data, correct?
Can you repeat the question?
Sure. There's all of the testing that's been done regarding the addition of Bitrex to products like antifreeze show that Bitrex does not prevent any types of poisonings with antifreeze, correct?
I'm not sure I can comment on that. I haven't read every study, so I can't say yes or no.
Well, that would be one of the most important ones for regarding your testimony here today, yes?
Yes.
Yes. And so as one researcher who conducted a test into this stated, despite the appealing logic of limiting the ingested volume and thereby the severity of poisonings by adding adverse agents, and despite promising results in volunteering studies, bittering agents do not decrease the frequency or severity of antifreeze poisonings, correct?
If you say so, yes.
Okay.
Well, just a minute. You can just say whether you're aware of it or not. And if you're not, that's the answer and that's the testimony.
Are you also aware, sir, that that denatonium benzoate is intended to deter the drinking of pure antifreeze, correct?
One of the substances,
Well, yes. Just in terms of, fair enough. We're just talking, just for purposes of this discussion, we're talking about antifreeze. Fair enough?
Understood. Antifreeze is, yeah.
Yeah, okay. So denatonium benzoate is designed to prevent the consumption of pure, well, not necessarily pure, but antifreeze.
Yes, yes.
Okay, and that's because antifreeze, ethylene glycol by itself is sweet tasting, correct?
Correct.
And one of the problems that people have had with it over the years is that it gets spilled on the ground. Animals will lick it up and essentially kill themselves.
Right.
Kids will drink it because a lot of antifreeze is bright colored and looks like Kool-Aid or sports drinks or whatever. Is that correct?
Correct.
Okay. And because it's sweet, it can be hidden in sports drinks or sodas or other sweet tasting drinks, correct?
I wouldn't know that.
You wouldn't. Are you familiar with the studies that show that when you add sugar to denatonium benzoate, the bitterness of the denatonium benzoate is markedly decreased?
I'm not aware of those studies.
Are you familiar with the studies that show that there has been zero impact on the number of ethylene glycol poisonings since bittering agents were added to antifreeze?
From what I've read, I have seen citations that said that there was not enough evidence. I'm not sure that I've read that there was zero evidence. It's just not enough is what I've read.
So you're not familiar with the fact that the poison control centers in the United States have concluded that the number of ethylene glycol poisonings have remained at the exact same level after the introduction of denatonium benzoate as before the introduction of denatonium benzoate to antifreeze?
I've read something to that effect, but I haven't delved into the numbers myself.
Okay. So what you've read in your studies of these things is that the denatonium benzoate does not have any effect on the number of poisonings for ethylene glycol.
That is a stronger statement that I can, I don't know.
Now, you said that the testing in this particular case was, for the sample, was done from September 12th to September 17th. Is that correct?
My notes say that the testing itself, the injection happened on the 12th, and then the report was issued on the 17th.
All right. So when you say the injection, what does that mean, sir?
In our process, we take an aliquot, a sample of a portion of the evidence sample. We dilute it to our method conditions that we validated prior to that, which then gets injected on our instrument, high performance liquid chromatography tandem.
Sorry,
Yeah.
I'm just going to stop you for a sec. Not because you probably are answering my question, but I just wanted to know, you started testing the liquid that came out of the Powerade bottle on September 7th, 12th.
Yes.
Okay. So that's when you inject it into your machines, and we don't need to.
We measured it.
I know there's a very scientific process that I'm not smart enough to understand, but that takes about 5 days and ends on September 17th, correct?
It's a shorter process, but the data analysis and reporting may take longer.
So on September 17th, 2025, that's when you or somebody else that you will work with is able to interpret the data and determine that there's these 114, we're just going to say 114 parts per million in the samples.
That is the date that we issued the report.
Okay. And is that the date that, so at some point between September 12th and September 17th, that's when you were able to reach that conclusion?
Yes.
Okay. So if you weren't able to reach that conclusion until sometime between September 12th and September 17th of 2025, how was it that other experts hired by the defense had your results in July of 2025?
I don't know.
That would seem...
I mean, I doubt they had that result.
So did you know a woman named Celeste Waring was hired by the defense in this particular case?
I'm aware of Celeste.
And you provided your results to her so she could make her own conclusions from them, yes?
There could have been preliminary results while we were developing the method. There could have been some preliminary results shared, but not the final validated conclusive result.
So you shared your results with her before you even validated it?
I mean, I don't know. I would have to check my records on what exactly was shared, but we had multiple phases of the project where phase one was to make sure that we can see, detect, measure.
Sure.
We tried, yep.
But that didn't measure what was in the Powerade bottle.
Not right.
That in September.
We did that in September. We measured using our validated method, and that's the result that we got.
So why was it that on July 28th, 2025, Ms. Waring issued her report in this case? How could she issue that report before you were even done with
Objection,
that?
Judge.
Let me see counsel at sidebar.
just so we're clear, none of that testing on the Powerade bottle liquid was done until September.
The final report was in September.
I'm not asking about the final report. I'm asking, you told us,
Yeah,
you told the jury on September 17th, you started testing the liquid in the Powerade.
September 12th.
September 12th, sorry, Jeff, thank you. September 12th, you started testing the liquid in the Powerade.
well, I was describing.
You told the jury.
Judge,
You-
he needs to be
yes-
able to
yes
answer
or
the
no?
question.
No, he's being, I'm going to permit Mr. Camilli to ask a yes or no question first, and then we'll see where that leads us.
You told the jury that you started testing the liquid in the Powerade on September 12th, 2025.
Okay, for that round, that would be correct.
Oh, so there's now,
But-
now
no.
there's multiple rounds. Is that what you're saying?
No, I was describing.
I understand. You were
Judge,
describing
the
how
report.
testing was done.
He should be allowed to say what he's describing,
Is,
or the prosecutor is going to be testifying instead of the witness.
Mr. Scully, I understand how this is supposed to work. Place your question. Let's hear an answer.
Well, okay, thank you.
Okay.
I
Go
appreciate that.
ahead. Say it again.
Let's answer the questions that I'm asking though, okay? So, did you start testing the liquid in the Powerade on September 12th, 2025, or was that not correct when you just said that?
Am I allowed to answer with context?
No. Did you start testing?
Or if, and if you believe that you cannot answer a yes or no question the way it's been posed, you can say that as well, sir.
I can't answer that question in that way.
So, the Powerade liquid. When did it start? When did you start testing?
That depends on what you mean by testing. May I explain what I mean?
No. No. Let's talk a little bit about Denatonium benzoate, Powerade, and Antifreeze. You're familiar with those three items, correct?
Yes.
Okay. Antifreeze is a liquid, yes?
Yes.
Powerade, other sugary sports drinks like soda or whatever, those are liquids.
Yes.
Denatonium benzoate is a salt.
Powder.
And over the course of time, liquids evaporate, yes?
They can.
The denatonium benzoate does not.
Correct.
So as time goes on, if the liquids, if the Powerade, and I'm saying Powerade, but don't necessarily know exactly what that means. I'm going to say Powerade just for ease of reference. So over time, if the Powerade was evaporating and the liquid and the antifreeze was evaporating, the concentration of denatonium benzoate in that solution, in that liquid, would be going up. Yes?
In that description, yes.
And when the defense expert came and took that Powerade from the state police in this particular case, he just poured it into a cup, open cup, like a little paper cup that you might drink a coffee out of. Would that increase the rate of evaporation?
Probably.
Not a particularly good way to transport or handle that type of evidence.
I'm sorry. I have no knowledge of what happened to the sample.
Well, I didn't
before.
ask you if you knew about it. I just asked you if that was a good idea.
I would. I don't know.
So you are familiar, sir, with the fact that antifreeze, that denatonium benzoate is by statute in Massachusetts and by agreement with every antifreeze manufacturer in the United States added to antifreeze, correct?
That's my understanding.
So every bottle of antifreeze sold in a commercial store in the United States contains a bittering agent, whether it's denatonium benzoate or it's supposed to.
Okay.
Okay. And that in Massachusetts, you're familiar with the fact that it's supposed to be between 30 and 50 parts per million, correct?
That's my understanding of the law. Yeah.
Okay. So that means if we have a bottle of antifreeze that's just antifreeze, the denatonium benzoate is 30 to 50 parts per million in that liquid. It's supposed to be.
It's supposed to be.
And people check on that sort of thing. There's testing that's done to make sure that the manufacturer is making it the way the law requires.
I don't know. I suppose so.
And every time you add something to the antifreeze, right, or you add the antifreeze to something else, you're diluting the antifreeze, right?
Yes.
Okay. So I got my little water bottle here that I've been drinking during the trial. If this is, we'll call it a half liter of water that's left in my water bottle, just for purposes of illustration, right? So if I add a half a bottle of water to a half a liter, sorry, let me back up. If I add a half a liter of water to a half a liter of antifreeze, I've now cut the denatonium benzoate parts per million in half.
Yes.
Okay. And so every time the antifreeze combined with the denatonium benzoate, something else is added to it, the parts per million of the denatonium benzoate goes down.
If that other component had no denatonium, then yes.
Right, thank you. That's an excellent point, right? So as long as I'm adding a substance to the antifreeze that doesn't contain denatonium benzoate, every time I add more substance to that liquid, the amount of denatonium benzoate in the solution goes down.
I hate to quibble, but the concentration goes down.
No, that's great. No, equivalent's great. So by the time you get to the point where you've now added, where the solution is 95% sports drink, for instance, and 5% antifreeze, the parts per million of denatonium benzoate in the solution by concentration is now about 1.2 parts per million, yes?
What are we starting with?
We're starting with 30 to 50, right? So let's say 40. Let's say 40 parts per million. We'll take the average, right? So you cut antifreeze that has 40 parts per million in half with a liquid that doesn't contain denatonium benzoate. You're now down to 20 parts per million, yes?
In that scenario, yes.
In that scenario.
Yes.
You cut it 75%, you're down to 10 parts per million, yes?
Yes.
You cut it to 90% and you're down to about 1.2 or 1.3 parts per million.
Whatever that number winds up being. Yep.
Nothing further, Judge.
Mr. Scully.
Just a few questions, if I may, Judge. So the prosecutor was asking you a lot of questions specifically about antifreeze, right?
Yes.
I'm going to grab the antifreeze that was seized in this case off the exhibit table. I'm sorry.
The wiper fluid, the RainX.
Is there any antifreeze, Judge?
Yeah. I got some at home. That's all right.
At home? Okay. So there's no antifreeze in this case. But maybe the source of the denatonium benzoate was antifreeze, right?
I guess.
You have no idea, right?
I don't know.
If it was antifreeze, there would be a law that says it's 30 to 50 parts per million, right?
Yes.
Is denatonium benzoate sold as a pure substance, 100% denatonium benzoate?
Yes.
Just hit a Google search and buy it. How many parts?
Yep.
Yes.
Yes.
How many parts per million in pure denatonium benzoate?
You wouldn't even describe it that way. It's a powder.
Oh, it's a powder.
Yeah.
But
It's a
100%,
million.
right?
It's a million parts per million.
It's 1,000,000 parts per million. Okay. So your testing wasn't designed to figure out whether there was antifreeze used in this case, right?
Right.
It was designed to determine whether there was denatonium benzoate.
Yes.
What were your results?
That the results were that the sample that we received contained, on average, 114 parts per million denatonium benzoate.
Okay. And how confident are you in those results?
I'm confident.
No further questions.
Mr. Camilio.
No, Judge, I think we're done.
Thank you very much, Mr. Khan. Thank you, Mr. Khan. Jurors, I had an opportunity during what was your extended break to discuss with counsel the schedule, so we don't need to go to sidebar for me to fill you in. The defense will be making some final determinations about its final witnesses. I expect that there will certainly be at least one additional defense witness tomorrow. I don't think that's going to be a particularly long witness. There may be one or two others. That remains to be seen. I don't think there was a possibility of another Commonwealth witness. I don't think that's the case now. The way things stand right now, I think there's a very reasonable prospect that this case will be going to closing arguments tomorrow. So you should all come tomorrow prepared to be here for a full day, because as I told you, once the case is handed off to the jury, the length of deliberations, excuse me, is entirely up to the 12 deliberating jurors, because you'll also remember that at the last stage of this trial, right before deliberations begin, 4 of you will be randomly selected to serve as our alternates. When that happens, we will literally take all of your jury numbers, put them in a little wooden barrel we have, and the scraper spins it around, and you don't win anything. Whether you lose depends on your perspective, I suppose. But 4 of you will be selected at that point to be alternates randomly. The other 12 will begin their deliberations. So they determine how long deliberations are. However long it takes those 12 individuals to resolve the issues in this case, as they see the issues, and to come to a unanimous verdict in this case, is the correct length of deliberations. But so long as the jury deliberates on any given day, they deliberate right up until 4 p.m., and we provide lunch for our deliberating jurors on any day that they're deliberating through that lunch hour of 1 to 2, and we provide lunch to the alternates who are kept separately from the deliberating jurors. So tomorrow, you should come with the expectation that if we get to the closing arguments, you'll start your deliberations and continue right up till 4 p.m. and ready to return on Monday morning if deliberations are continuing, and forever, however long it takes, as I say, those 12 jurors to come to a unanimous verdict. So that's the way things stand. I know today's a relatively early day for you. Counsel and I still have some work to do because, among other things, we have to have what's known as a charge conference. I provide copies of my proposed final jury instructions to the lawyers, and then we have a conference about that where they can give me some suggestions, which I usually reject, but they have the opportunity to do so. Discussion, we finalize the instructions. So the other thing I'll remind you is tomorrow, when we finally do, if we do get to the closing arguments and the instructions, you'll have written copies of my legal instructions, so you'll be able to use those at that time. So this is a long-winded goodbye. I'm going to end it right here with my usual admonishment to all of you. You know what it is. Until we see each other again tomorrow morning, please don't discuss the substance of this case with anyone, including among yourselves. And please don't allow yourselves to see, read, hear, or overhear anything from any outside source about any aspect of this case. I want to thank you very much for your time and attention, and especially for your patience. I think all counsel really wished that all of the witnesses were available so there were no interruptions and we were just able to go up to 4 p.m. each day to get this case in most efficiently. It's really not within their control, the availability of some of these witnesses. And so once again, please don't hold any frustration against them or the parties they represent. Thank you very much, and we'll see you tomorrow morning.
All right.
We'll remain in session. Mr. Camilio or Mr. Strasnick, Ms. Strasnick, have you had an opportunity to take a look at the jury instructions?
I did briefly. There's another issue we can talk about after relative to one of the defense experts that I wanted to raise with the court, but I couldn't.
Oh, you can raise that now, then we can deal with that first.
So Mr. Lakin was on the defense witness list. At some point I thought that they had said he was going to be in the courtroom during the DNA testimony yesterday. So I reached out to see if that was the case, or if he was going to be testifying, because we got no report or anything. I was informed, based on my conversations with defense counsel throughout the trial, that if he was to testify, it would be in the area of transference and potentially questions about contamination relative to the swabbing that Ms. Hooper testified to, which is all areas that, despite not having a report, the Commonwealth was on notice of to some extent. Today, I got a written disclosure relative to Mr. Lakin's testimony, which I can provide to the court. And I have some serious concerns relative to areas that he now expects to testify to. I can tell the court I ran into this with him on a trial that I had about a month ago where he started testifying to things that we weren't on notice of. It was ultimately excluded, which is why I was hypersensitive to make sure that if he was testifying, there was a report. He wants to now talk about Bayesian statistics.
Hey, what was the first thing you just said?
I actually don't even know. But
What's it called?
Bayesian statistics. And I did make a copy. I can provide the notice I got to.
Bayesian statistics?
Yes, the
Okay.
binomial probability formula, odd ratios, probabilities, binomial distributions, random match probabilities, and involving mathematical calculations, gene frequency calculations, population genetics, and assumptions under the Hardy-Weinberg model, which is just very different than transferred DNA or potential contamination. He does also plan, I guess, to testify on some of our DNA results. I just think that it's very different to be provided the notice of this type of witness with this type of testimony the day before he's supposed to testify, when that is not at all what was indicated about his testimony.
Mr. Norkunis?
Judge, the document we have here today, the first paragraph, in my opinion, is what I think we had talked about. He'll testify to. Then he has quite an elaborate background, and the rest of it was that what Mr. Strasnick just told, he's not going to do that, Judge. I don't know why that was added. I have no questions in that field. I don't understand any of those terms.
So you're not going to be asking him about, tell us all about Bayesian statistics and binomial probabilistic formulas.
No.
So you are telling me, Mr. Norkunis, you're going to stick to questioning him about what you've told the Commonwealth all along would be the subject matter, which is how DNA gets transferred, potentially?
Yes, essentially. He has quite an extensive background. I am going to ask him that, Judge. He's formed a lot of companies to do it. And it, gives substance to his testimony as to what he's doing. His last paragraph, he actually says he agrees with the statistical assessment done by the DNA experts in this case. I haven't seen that, but the government may ask him about that.
Okay, so yeah, I imagine they will. All right, well, on that representation, I don't think there's anything to discuss because I'm going to hold him to the subject matter that's been disclosed up to this point. The Commonwealth has been patiently awaiting the actual report.
Yep.
I'm glad this was brought to my attention. I think Ms. Strasnick will be prepared to deal with him in terms of the usual testimony about how DNA may get transferred. And he starts straying into anything else, there's going to be an objection. I'm going to sustain it, and Mr. Norkunis is not looking to do that in any event, so that's fine.
I understand that, Judge.
Okay. Now, in terms of the jury instructions.
Judge, for the most part, they look fine. Two issues that I wanted to just raise that Ms. Strasnick actually brought to my attention. One, the court does have a section in here about prior inconsistent statements.
Yes.
I would also ask that the court add a paragraph to the end or its own paragraph in there about prior consistent statements, because we had on two occasions prior consistent statements being introduced or read into the record with regard, I believe, with Mr. Certainly one with Mr. Hawkins and the other one with Mr. Haywood. So I would ask the court add that at some point in there.
Well, the difference is, I don't think I've ever given an instruction on prior consistent statements, even when they've been elicited, is that the prior inconsistent statement explanation is to say that they have a limited use at a trial unless under oath or unless informed by the witness, because if not, they only go to the assessment of the witness's credibility, whereas a prior consistent statement, I didn't if it comes in as a hearsay exception, and they don't have that limitation, so I generally don't explain anything about it.
I understand that, Judge. I just think for a jury that is not going to be super familiar or probably have any familiarity with the rules of evidence in the hearsay rules, that sort of distinguishing between a prior inconsistent statement and a prior consistent statement could be difficult. So I would just ask that the court let them know that prior consistent statements can be considered for the truth and, for any purpose that they decide to use it for. It's not limited like a prior inconsistent statement is.
All right, I'll consider that.
Thank you.
I understand the point.
Thank you. And then I don't know if I missed it, just not a header for it. But in the evaluating the witness's testimony, you do, okay, never mind. It is. So the only thing that the court's going to have for the expert testimony is just sort of the 3 sentences that are on page 30. Is that fair?
If so, there's a mistake, so let me take a look.
I just need a minute to catch up on that too. Page 30.
Oh, sorry, it's page 30 that seems to be. I think all right. I think that is actually normal.
Opinion evidence, I have, in the copy I have before me,
Yeah.
I have multi-paragraphs.
You do, Judge. You judge, and we missed the entire expert part because there was not a separate headline for it.
I
do see the whole thing now.
It's listed as F, opinion evidence.
Yes, I know. We were just looking for a separate section for expert.
Oh, no, it's part of the, okay. But yeah, that's the standard expert witness instruction. Who's got the jury instructions, Mr. Scully or Mr. Scully? We had you brought to my attention yesterday the Bowden request, which, but I'll hear whatever you wish to say.
Thank you, Judge. We would request that in this case. I think one of the issues with the instruction that we submitted, and there's a second instruction as well, sort of the modified Bowden, but we're asking for the full Bowden because we think this is a scientific case. And
you asked for it in writing. I mean, I'm familiar with Bowden instructions, but I don't.
Oh, I'm sorry.
If you filed one, I don't have it in front of me.
I meant to hand it in. It's the model instruction 3.74.
That's fine. I'm familiar with the model instruction, so no worries.
Yeah, I meant to hand that in. I don't think I did.
That's fine.
I had a false memory on that, Judge. So I think one of the issues that comes up is, are we entitled to this instruction? First, whether the omitted tests or actions were standard procedure or steps that would otherwise normally be taken under the circumstances. And in this case, what's interesting is that NMS Laboratory, the witness who testified, had only done one other EG case, the one in Los Angeles that he mentioned in his testimony. And the police, I think, and this is relative to failing to test for the bittering agent.
Right.
I think Trooper Williams, said in part, well, I did a Google search and there was, it's all over the internet. There's cases like the one with the woman who poisoned someone with antifreeze. And so we don't have to do that testing, right? But there isn't really, I don't think, evidence that this would be a standard procedure done in these cases because there's not enough cases that people testified about. What's interesting, though, is that it's a matter of common sense. And I think the second phrase, or steps that would otherwise normally be taken under the circumstances, that's, I think, a determination for the jury to make. And the instruction is proper because the defense puts forth the argument that a fair prosecution would have taken these steps. An engaged investigation would have taken these steps to try to find out whether or not this bittering agent was in the substance or not. And obviously you've heard all about that. They didn't know about it at the time, but they were alerted at some point that it existed. It was on the deicer label and so forth, and there's a general law, right? So we think because it's up to the jury to decide whether these steps would have been taken normally under the circumstances of this case, we would be entitled to this instruction, Judge.
All right. I appreciate the argument. What's the Commonwealth's position with respect to a Bowden instruction?
I would ask the court not to give a Bowden instruction, Your Honor. I think Mr. Scully just said to the court that these were not standard procedures or steps that would normally be taken, which is one of the sort of benchmarks of whether or not Bowden should be given as an instruction. Obviously, I can't remember the last time I tried a murder case that didn't have some sort of claim of Bowden on behalf of the defendant. It's a fairly standard defense tactic, obviously, and it can be effective used in the right ways. But I've also never actually seen a Bowden instruction given. So, and I understand that is not what controls here, but the jury is going to hear in the closing arguments all about the supposed missteps of the Commonwealth or of the investigation. I don't think that this is a particularly egregious case. Obviously the Commonwealth disagrees quite strenuously with the way the defendant characterizes the investigation and the evidence, and so it really should be up to the jury to decide what weight to give it and how to use it in their deliberations. I don't see any basis here for the court to draw a special attention to it any more than any other part of the evidence here that the jury is going to be considering.
All right, thank you, Mr. Camilio. I am not going to give a Bowden instruction. I did mention yesterday that I rarely give it. I think I can recall one or two occasions when I have given a Bowden instruction. The case law tells me that the one thing I cannot do, and I have not done at all in this case, is take the Bowden issue away from the jury. This issue is squarely teed up for the jury. I expect it'll be forcefully argued in closing argument. It's been the subject of a fair amount of the examination of witnesses, all appropriately so. So the issue itself is, as I say, squarely before the jury. I have in no manner restricted that. The case law also tells me that the fact that I may have instructed the jury on the limited Bowden use of certain pieces of evidence that came in aid of the Bowden defense does not mean that a full-blown Bowden instruction and final instructions is required. And in fact, the case law says that a denial of a request for Bowden instruction is never an error. It's a matter of discretion with the judge. And finally, as I mentioned yesterday, it's really a disfavored instruction because it can be viewed as putting the thumb on the scale a little bit, drawing attention to a particular issue rather than just letting both counsel argue it based on the evidence that has been presented. The occasion or two on which I've given it, the investigatory lapses that were alleged were indisputable and so arguably egregious that in those cases I viewed a Bowden instruction as being warranted as a rare exception to my general rule. This is not such a case. It's, as I say, squarely and properly in front of the jury, and I expect it will be forcefully argued. But particularly, for example, listening to Mr. Kahn testify that he had to invent a test, come up with a protocol, and validate it for even testing for Bitrex, I'll use that phrase instead of the actual chemical name, tells me that it's something that is cannot have been expected as some sort of matter of course by the investigators in this case. So I'm going to deny the request for a Bowden instruction for those reasons, as per my usual approach in these cases, and all rights preserved for the defense. What else, Mr. Scully, in terms of the instructions? Anything else?
Can I have a moment to confer with counsel?
Certainly.
We got the microphone here, so. So, Judge, I did look over your instructions. They otherwise look complete to me. So at this time, we have nothing further. I'm going to take a second, probably a fifth look at them. But
well, please do, because tomorrow morning, before we get together with the jury, the first question I'm going to ask you, Mr. Scully, is whether it's Ms. Church's decision to testify or not. Because, Mr. Norkunis, and I will ask him tomorrow morning, because if the decision is to testify, well, either way, I have to just make sure that I eliminate the prompt on that portion of the instruction as to the defendant not testifying. And if she doesn't testify, I have to take out the entire section. We have to do that and start making copies because it takes some time to do that. Okay. So I will just put that question to you first thing, Mr. Narconis.
All right.
Mr. Camilio?
Two things. The first one I remember. Mr. Narconis and I executed a stipulation tomorrow that we can read to, this morning, that we can read to the jury at some point tomorrow that just states that Ms. Church was charged with first-degree murder on December 22, 2022 in Salisbury, Massachusetts.
All right, let's mark that for an exhibit, as an exhibit right now, and just remind me tomorrow morning, I'll read it to the jury, and I'll remind him what a stipulation is.
Thank you.
Thank you.
Oh, yeah. The other issue, Judge, is that the medical records in this case came in subject to redaction.
Right.
Based on whatever rulings the court makes and the parties think are appropriate. So two things with regard to that. We can take a crack at that this afternoon to the extent that, everybody has enough time, we can look at them. But if Mr. Scully had indicated at sidebar earlier that he might read from them, so if he is going to do that, if I could just have notice as to what the passages are, so if they are things that I would be objecting to, we can deal with that before they get read rather than in front of the jury in the middle of it. If he's not going to read anything, then we just have to get them redacted before they go back, obviously.
I think that's fair and appropriate, Mr. Scully. If there are some passages from the various records that are in evidence that you wish to read, and I indicated to you, I give you the opportunity to do that. Please flag those because they may present a redaction issue. I don't get involved in redactions unless there's a dispute that I need to resolve. So I'm really leaving it to counsel, but that work needs to be done perhaps by the attorneys not doing the closings because once the closings and final instructions are given, I don't want the jury waiting for the finalized versions of the medical record exhibits. And I will deal with any disputes that come up and you bring to my attention. But Mr. Scully, if you'd think about that and just let the prosecutors know. So if they have an issue with any of the passages, I can deal with that first thing in the morning.
Will do, Your Honor. Thank you.
All right. That's all I have for now. Everybody's got a little time on their hands. All right. Thank you. Ms. Draper, do we have probation this afternoon? Good. That's fine. All right.
Court, all rise.